saw debates on OBC reservation with the concept of creamy layer being extensively discussed. So we began KYC or Know Your Constitution this week by telling you about the creamy layer and what the controversy around it is all about. Now, to trace the genesis of the concept of creamy layer, we'd have to go back to 1979 when the Mandal Commission was set up under Article 340 of the Constitution by the Janata Party government under Prime Minister Morarji Desai. Article 340 specifically provides for appointment of such a commission by the President to look into the conditions of socially and educationally backward classes within India. The commission is supposed to make recommendations on how their conditions can be improved. The Mandal Commission recommended that OBCs should be granted 27% reservations in government jobs, schools and colleges. These recommendations were accepted by then Prime Minister VP Singh in an attempt to neutralize BJP's politics over Ram Mandir in Ayodhya. The country saw widespread agitations in 1990, leading to petitions being filed in the Supreme Court. But a 9-judge bench in what we now call the Mandal Commission case upheld reservations for OBCs. It, however, ruled that creamy layer among these backward classes of citizens shouldn't get the benefits of reservation. As to what constitutes creamy layer, the court left it for the central government to decide. In 1993, the government laid down the criteria. Among other things, households earning more than 1 lakh annually were considered to be a part of the creamy layer and so were not entitled to get the benefits of reservation. But this 1 lakh income had to be calculated from sources other than government salary and agriculture. The ceiling has been revised only 4 times since 1993. Currently, households with more than 8 lakh annual income are ineligible for reservations. As per news reports, the National Commission for Backward Classes was planning to demand raising this 8 lakh ceiling to 16 lakhs. Naturally, increasing the 8 lakh threshold would allow more OBC candidates to get the benefit of reservations. But the controversy actually surrounds the calculation method for annual income. While earlier government salary was not considered while calculating the annual income, reports claim that the government now wanted to include an individual's salary to calculate household earnings. This will lead to the exclusion of several families from the benefits of reservations, but the proposal has seen opposition from various quarters, including Tamil Nadu Chief Minister A.K. Palaniswamy. On Wednesday, Rajasthan Speaker C.P. Joshi issued notices to Sachin Pilot and 18 other party members after Congress sought their disqualification from the State Assembly. So on KYC Next, we told you what the anti-defection law is all about and what will happen next in Pilot's case. Now you must have heard about the phrase Aya Ram Gaya Ram. It actually became popular in Indian politics after Haryana MLA Gayalal changed his party twice within a few hours and thrice within a fortnight in 1967. Naturally, the need for a law to prevent this arose. The Rajiv Gandhi government finally brought a bill to amend the constitution and curb defections in 1985. The 10th schedule of the constitution, which contains the anti-defection law, was added to the constitution through this amendment. According to this law, an MP or an MLA is understood to have defected if he either voluntarily gives up his membership of his party or disobeys the directives of the party leadership on a vote. And the result of abstaining from the voting or voting against the party whip is that the legislator can lose his membership of the House. The Supreme Court has also held that for a member to be disqualified, he doesn't have to necessarily formally resign. It has said that members who have publicly expressed opposition to their party or support for another party were deemed to have resigned. In Pilot's case, Rajasthan Congress in charge Avinash Pandey had said that the notices were issued because Pilot and other members defied a party directive by not attending its legislative party meetings this week. They will now have to respond to the notices, following which a rejoinder may be filed by the Congress in response to Pilot's answer to the notice. The Speaker will then decide on the disqualification. While the Speaker is supposed to take a decision on the disqualification petition within a reasonable period of time, the Supreme Court in January held that it should usually be within 3 months. The Sachin Pilot saga then moved to the courts, with Pilot and 18 dissident Congress MLAs approaching the Rajasthan High Court on Thursday. They have challenged not just the disqualification notice issued to them by Rajasthan Assembly Speaker, but also a part of the anti-defection law itself. 10th schedule of the Constitution contains 2 grounds for disqualification of lawmakers for defection. The first ground under clause 2(1)(a) is that if the MP or MLA has voluntarily given up the membership of the political party on whose ticket he was elected. The second ground is if he votes or abstains from voting in the House contrary to what was directed to him by the party, that is, if he violates the party whip in the House. Pilot and the other MLAs have been issued notices on the first ground, and it is this ground that they have challenged in the High Court. Now, while the 10th schedule itself does not offer much of an explanation on what voluntarily giving up party membership actually means, there have been Supreme Court judgments explaining what it means. For instance, in 1994, the Supreme Court held that for voluntarily giving up party membership, it is not necessary for the legislator to formally resign. It said that giving up membership can be construed from his conduct as well. So in 2007, the Supreme Court upheld the disqualification of 13 Bahujan Samaj Party MLAs who had supported Mulayam Singh's claim to form the government in 2003. The court said that even signing a letter to the governor supporting the opposite party amounted to defection. But in 2011, the Supreme Court set aside the Karnataka Speaker's order disqualifying 11 BJP MLAs. These MLAs had approached the governor saying that they had withdrawn their support from the government led by Yediyurappa at that time because he was corrupt and had lost the confidence of the people. The Supreme Court struck down their disqualification, noting that they had continued to be members of the BJP but were merely against Yediyurappa. Pilot and the other MLAs have now challenged this provision, saying that merely expressing dissatisfaction against the party leadership cannot violate clause 21A of the 10th schedule. They have therefore challenged the provision, saying that it violates the fundamental right to freedom of speech and expression. Now here's a question for you. What is common between the Supreme Court verdicts on Babri Masjid Ram Janmabhoomi dispute, instant triple talaq, fundamental right to privacy, Aadhaar scheme and Sabrimala temple? The answer is that all these cases were heard by a constitution bench in the Supreme Court. But have you ever wondered what a constitution bench exactly is? We told you next on KYC. Now, a significant number of cases before the Supreme Court are heard by 2-judge benches, which are called division benches, and a few are heard by benches with 3 judges. A constitution bench is an exception to this. It comprises of 5 or more judges. According to Article 145, Subclause 3 of the Constitution, any case involving a substantial question of law on the interpretation of the Constitution itself would only be decided by at least 5 judges. It also says that any reference under Article 143 would also be heard by at least 5 judges. Now, Article 143 talks about the precedent seeking the Supreme Court's opinion on a factual or legal question. These benches can also be set up if 2 or more 3-judge benches have delivered conflicting judgments, therefore needing a judgment by a larger bench, or when, say, a 3-judge bench doubts the correctness of a judgment by another 3-judge bench. Of course, there are benches with more than 5 judges too. This may happen if a subsequent 5-judge bench doubts the correctness of an earlier 5-judge bench ruling and refers the matter to a larger 7-judge bench. The largest ever constitution bench in India had 13 judges to decide the landmark Keshwanand Bharti case. Several important cases are currently pending before the Constitution Bench of the Supreme Court. These include the case on rights versus faith issues relating to religious practices that restrict women from entering mosques, Parsi worship places and the Sabrimala temple. The petitions challenging scrapping of Jammu and Kashmir's special status under Article 370 and 35A and the validity of the Citizenship Amendment Act are also currently pending before the Constitution Bench. The hearings in these cases had been put on hold because of COVID-19, but on Tuesday, the Supreme Court held its first ever Constitution Bench sitting through video conferencing. The bench is considering whether the central government can provide reservation to in-service candidates, that is doctors already in government service, in postgraduate medical degree courses. This is Apoorva Mandhani for ThePrint. For more such videos, subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.